Thank you for watching. In this short video I want to explain very briefly the difference between a brief specification, a brief patent specification, and a detailed patent specification. I think a specification, a patent specification, should be instead detailed for the following reasons. Let's say the inventor invented a device like represented by these 4 sets of building blocks. He invented a device in 4 different variations, and he realized by his research and development that all of these variations could work equally well to solve the problem he identified. In that case, I think all of these 4 variations should be described in the specification, in coordination, of course, with the drawings, to explain these variations very well in the specification. Why is that? Because first, reason number 1, there is a full description requirement according to US patent law, which means that the inventor has the obligation to demonstrate to the patent office that he is in possession of the invention, meaning that he knows how it works, how it has to be built, and so on. The reason number 2 is that there is what is called an enablement requirement. The inventor has to demonstrate to the patent office that he provided sufficient information, sufficient details about his invention in the specification in order to enable one of our skills in the art. And that could be a mechanical engineer if we are talking about a mechanical device, or it could be a doctor if we are talking about a medical device. These 4 variations of the device could be also the 4 claims of the patent. Let's say that during the examination of the patent application, the examiner does a prior art search, and he found prior art against this particular variation, which is recited in one of the patent claims. The examiner says, I found something that is exactly the same or very similar, so this claim is not novel or is obvious over the prior art I found. The patent owner may think about maybe amending this claim by adding an additional limitation represented by this green building block to distinguish over the prior art that the examiner found, to say, hey, I have now a different claim, it's different than the prior art you found, I believe this is patentable. The examiner may say, okay, fine, that's true, but when you presented the specification, you failed to describe this particular variation in detail. Will be sufficient to enable one of our ordinary skills in the art to make and use this variation. So this amendment that could have worked will fail now because there were no sufficient details in the specification to support this amendment, to support this additional element of this claim and support this particular variation of the device that you now want to claim, because claiming this variation, which of course is a broader claim, it failed because the examiner found similar or the exact prior art. I hope this helps. Thank you for watching.